Now I would like to open the floor for discussion. We actually already have one questions directed to Dr. Melis Ozdel, if I may read it for you, Melis. This question is from Adam Suharto. The question is like this: how does the doctrine of causa proxima or proximate cause operate
Yeah,
in the event of cyber attack and so on and so forth? I think you can also read it, right?
I can't. I don't think I
You can,
can.
okay, right. Let me just read it for you. Uh,
Okay. So
operate in the event of cyber attack that disables a vessel's navigation system which within a conflict zone. So would such a loss be classified under perils of the sea, standard marine insurance, or
I
war
have now.
terrorism risk?
Okay. So I
Is
have
it?
now seen it. So
Yes. Okay.
okay.
Yes.
So right. So okay. Right. Okay. So the crucial thing obviously
Please.
here is to just bear in mind. We don't obviously expect just one cause leading to whatever damage it may well cause to the vessel, right?
Mm,
So obviously, doctrine of proximate cause, as it was put in the question, it will depend, obviously, on the situation here. So what I would say, if a vessel's navigation system within a conflict zone, the course will usually look at, so there are a number of things. So whether there is the effective cause or the dominant cause. So you may need to look into the situation because it depends on the question that's being asked. So, for
mm,
example, if you have got a case of indemnity in the context of a time charter, the test there is not proximate, but the effective cause. In many seaworthiness cases where it is combined with dangerous cargo, etc., again, the question was based on not the proximate cause, but the effective cause. Um, so so the crucial thing obviously here is first you need to identify in what context you ask the question.
mhm,
Because proximate cause is not it's something that is mainly discussed in the context of insurance. But in the context of carriage of goods by sea, we increasingly see reference to effective cause than the proximate cause. And an effective cause is the operating cause. It doesn't have to be the dominant cause, if that makes any sense. Um, so so that is why you need to look at it in that context and how the so how the war risk clauses were interpreted, how the damages clauses, if there are any damages clauses are in there. So you need to therefore look at the contract as a whole to find out. But mainly where you have got more than one cause leading to the loss, you need to first find out in what context you're asking, in what context you'll be determining the liability issues. And depending on that context, yes, but for test is not relevant because we do tend to see usually one cause leading to the loss. And we therefore need to then ask ourselves the question of, are we looking for something dominant or would just effective cause be sufficient? And in the context I have mentioned, sometimes just effective cause can actually do the job. And so as long as it's something that is the operating cost, then it might well be possible for you to rely on whatever you want to rely on. So that is how I would say it's there's nothing of it. So let me just see. So cyber criminality and
mhm,
state-sponsored aggression. I'm not quite sure what is meant by that. So
mhm.
cyber criminality and state-sponsored aggression. I'm not sure. So I need more clarification on that. And what I can say is, and there's no one single test of causation. So you need to look into in what context you're asking that
Mhm,
question.
mhm,
Because the legal question do change, and we don't necessarily look for approximate. Sometimes effective cause can actually do the job. And what causation is going to apply, and in what context you're
mm,
looking at, you need to look at the contract as well. So cybersecurity, that matters sometimes, is
right.
regulated fact. So you need to look into the contract in place to find out how you're going to fit that within the whole liability spectrum. So that is also quite important. It's an interesting question. So thanks for that.
Mhm. Thank you, Melis. If I may add a little bit, based on my understanding, in
Mm.
general, this is how I understand this. We have event, and that event can be categorized into one or two. So now we understand that the borders between these different categories are getting thinner or even blurred. Do you agree with that, Melis?
In what context? I mean, it does blur. I mean, causation is always a problematic area of law.
Right.
We have had situations, I mean, especially if you just move into tort law, then the causation issue gets even worse. Now, our understanding, and I think I should also mention, so English contract law is not based on fault. So you don't breach it.
Right.
So we never actually look into anyone's mindset or whether they were actually faulty in the civil law sense. That's not what we do. They have an obligation. If that is not complied with, whatever, then they are in breach. So normally most of the causal issues and contributory negligence kind of stuff, we are able to just put that aside most of the cases. But sometimes obviously it's not possible. And especially in carriage cases as well, where you have got more than one cause leading to the loss, then you come up with no. If I may just give you an example in the carriage context, because it's quite relevant to what I have discussed. Probably many of you would know indemnity. So at time context, there is the implied indemnity obligation by the owners in relation to losses arising from their instructions. So very relevant to what we have got at the moment, right? So maybe the owner may need to pay a really large fee, let's say, to an authority so that the vessel can safely pass through the corridor. Let's say 2 million they're speaking of, right? So can that sum, for example, be recovered from the charterers? But the crucial question is, well, you may not always be in a position to have this direct causal link between the loss and the charter's instructions. A lot comes into play, right? So you give the instruction to the master. Now the master is in charge. Whether he's actually should be expected to comply with it, how he's going to react to, let's say, imminent danger that's happening there, the contribution of third parties involved, in situations like this, right? So in many cases, the courts had no option but to say, we're not looking at the immediate cause of the loss. We need to go beyond that and ask ourselves the question. We're not going to go with but for. We're not going to look at immediate cause. We need to look beyond that and say which one is the operational one, which one is the effective one. So causation is a difficult area. The thing, obviously, in practice, in legal practice, that's what we know. So it's a factual matter. So it will be obviously up to the arbitral tribunal or the first court, the first court, to decide about the questions of fact. But it's really a fact-driven analysis. And what we can just get from cases is but that is because of the nature of causation, isn't it? It's just the way it is. So you can't have a hard and fast answer to these questions in a way.
Right. Thank you so much. I would like to remind participants to ask questions through the Q&A facilities that we have in our Zoom. Now, the second question, I think this is from Dr. Fatih Cemal Karaitu. This is for Ibu Tiana. Yeah? So, two questions actually. One of doctrine view on the relationship between LMMC and other convention is a matter of priority. That's the understanding. It is said that LMC is, in general, a general framework of vessel ship owners' sole liability, which arise by other convention, cannot exceed the limits in the LLMC. So do you have any comment on this? That is one. And the second will be actually not part of the presentation, actually, this question, but related with the presentation topic. How do you interpret Article 4 of LLMC in Indonesian maritime law? Tiana.
All right, thank you for the question. So Regarding LMC, it is correct that this is a general limitation regime, but saying
Mm,
that it always has a priority over the other
mm,
conventions is, I'd say that it is too absolute. So, first of all, I would like to put out there that for Indonesian context, since you've asked in your
mm,
second question about the application to Indonesian maritime law. So LMC and Indonesia is not party to both of these conventions, the Athens Convention and LMC expressly. So maybe first of all, you would ask like if these two conventions were not ratified or applicable in Indonesia, then why are we discussing such matters? So
mm,
first of all, Indonesian ship owners who are operating internationally, particularly who those ships call at ports of LMC state parties, they should be aware that they may be subject to the convention if the trigger applies, in which if it's applied by the flag state or port state of the incident, not Indonesian law. And for Indonesian passengers, if they travel on a foreign flagged vessel, and an incident occurs in a state party in which they are a member of the conventions, then foreign courts or those jurisdiction may apply if they are state party to LMC, and the limits to their claim would also be applicable. And the Indonesians' non-party status does not protect Indonesian passengers from having their recoverable compensation capped by another state's application of the LMC. As for the question earlier, um, sorry, where is it?
can you see that?
Yeah, the first exceed limits of the LMC. Yeah, so
Mm,
it's not just the LMC, but the Athens Convention as well. So
right.
it does not mean that one convention applies and then the other does not. So it could apply both of them. It's a separate regime, and each convention has its own trigger rules. But their special conventions are often override or bypassed by the LMC. And if for Indonesia, since we have not ratified both conventions, so if the incident occurs in Indonesian waters, then that means that the domestic law applies.
Mhm.
And I hope that answers your question.
Okay. All right. Thank you so.
Here, I
Dr. Osdell, do you have
may
any
I read it out
adding?
first? I think that I got one question here. So it reads,
Yes.
in a case where a vessel becomes disabled
Yep.
during transit, the cargo remains intact.
Mm.
Should this be treated as a foreseeable contractual risk that will expressly indicate it? So are there being clause or stamp provisions that are useful to include in future contracts? It's a very, very good question. It's just it has got a lot of components. So first, let's start with the first one. So if a vessel becomes disabled during its transit, but the cargo remains intact, should this be treated for sea? So we obviously need to know why the vessel, if we are thinking of the current.
I think connection problems, right? Dr. Osdell is not no longer with us, correct?
Yes, same with us.
Right. Okay. Uh,
She's back.
well, okay. He's back. She's back.
My apologies. My
No
apologies.
problem. Please continue.
Carry on. So we obviously need to know why the vessel became disabled. So the cause of that is going to obviously give us whether this is a foreseeable event or not a foreseeable event. So the causal connection is quite important there. Assuming this is, the current crisis that we have. Again, whether it's a foreseeable contractual risk or not will depend. Because the crucial thing here is foreseeability is assessed at the time of contract conclusion. Everybody now knows whatever happens there. it's a foreseeable event. So if you send your vessel there around that region, it will get stuck, if not damaged. We know that. But when assessing foreseeability for the purposes of allocation of risk in charter parties, in sale contracts, in any, we basically look at whether this was foreseeable at the time of contract conclusion. There are so many cases, English cases, where they actually guide us through this and say, on the issue of foreseeability, you need to look at the time when the parties conclude the contract, not afterwards. So that is the first thing. The second thing is that ought to be expressly allocated. So foreseeable contractual risks, as I said earlier, it will be ideal if you actually have got something in place in your contract that deals with whatever contingency that you think might occur. I think it definitely puts parties in peace, in their minds in peace, and it will be the best solution forward. Because as I said earlier in my presentation, look at House of Law decision in the NEMA. They clearly say, and I just repeat, unforeseeable events are likely to give rise to frustration, but you may sometimes have cases where you predict a foreseeable event. It may well be, things that happened in the past. Foreseeable events can also sometimes give rise to frustration. Not necessarily. The likelihood there is obviously not as much as what you would have if you have got an unforeseeable event. But at the end of the day, this can't be ruled out. Frustration can't be ruled out just because the event seems to be possible, foreseeable in the future. So the best thing I would recommend is to have some contractual provisions in place, because frustration is also not the best way forward. You may well say, oh, it's fantastic. When the contract is frustrated, I'm discharged of my contract obligations, happy days. Well, not necessarily, because once this happens, you have no control over it. The frustrating event is going to kill your contract. Both parties will be automatically discharged from contractual performance. Maybe you had some reimbursement issues, maybe you had some issues there, maybe you just incurred some expenses, assuming that the contract will go on. It is never a good thing to say the contract now is discharged automatically, parties now have got no control over it. It's better to think of these things ahead. It's better to cover the contingencies that you think are likely to happen. It's better to have those things. And that is why organizations like BIMCO, they just sit down and do the necessary work to think about all the contingencies, so the parties will know where they stand, where uncertainty happens, where things happen, when seemingly unforeseeable things happen. Would I recommend any clauses? That was the final bit of the question. So you have wartime and war clauses. So the recent versions of those are 2025. I think it will give you a good security in place so that you will know what to do. So, for example, in the question you asked, so what happens? You have a cargo that becomes intact. So you have got, for example, War 2025 void charter scenarios, if we look at it. So it comes up with lots of options. So if before loading, if the place that the vessel was going to proceed becomes dangerous due to a warlike situation, so if the risk is identified prior to loading, the owners can cancel the voyage if alternative nominated. Or void. So this is what obviously being asked for 2025. The owner or the master can suspend operations or proceed to a port of this and entitlement to additional freight where applicable. Alternative routing might be possible if you're not yet trapped, for example. Insurance contributions also are there. Increased insurance actually incurred. Securing the BIMCO clauses I have mentioned. But again, a word of caution, because of the Supreme Court cases I mentioned, these clauses will not be read in isolation from the other things that you put in your contract. So please make sure you have consistency. And please make sure you don't put anything that's going to undermine or weaken
Is this gone again? All right. Welcome back.
So final word is, so you must make sure that you don't have anything conflicting or undermining that are given to you under these clauses. So that's the most important thing.
Right. Thank you very much. We still have not that much, like 8 minutes. I still have one question I made to Ibu Tiana. This is probably a little bit more practical. So in practice, do you think the current liability limits under the LMC and Athens regimes remain adequate for modern cruise incidents involving, for example, thousands of passengers? What do you think about that? Still muted, sorry.
Apologies, Dr. Andi. Can you please
Repeat.
mention
Okay.
your question again?
Sure. So in practice, do you think the current liability limits under the LMC and Athens regimes remain adequate for modern cruise, for example, the one or modern cruise incidents in this case involving, let's say, thousands of passengers? Do you think it's adequate for that?
Right. So I think there may be a gap in both conventions that the presentation does not fully address. So it's important to note that the war risk itself, because we are talking about war risk in this context, it does not clearly defined by the either the LMC or the Athens Convention itself. So in the light of the events that is currently going on in the Middle East, there also may be a possibility that there will be developments in response to this situation. And also, this is we were talking about the in personal injury and deaths as well. But if you are asking about as to whether or not compensation is adequately or sufficiently addressed in both conventions, I think there may be a gap in both conventions in some areas that maybe not necessarily mentioned or highlighted in today's presentation. It is the issue of a pure economic loss by the passengers, or repatriation costs, or stranding expenses. Because earlier we did establish that some shipwreck incident, the shipping incidents may not be applicable to what is happening in our real life case, in which that may not be classified as a shipping incident because it's not a shipwreck and so forth, but it's to the fact that the vessel itself is just hindered, or it's obstructed to the fact that they are stuck in the Persian Gulf or in Dubai, and they just simply cannot pass or continue their voyages. So maybe under the LMC Article 2, paragraph 1.b, if I'm not mistaken, the claims for loss resulting from the delay of carriage by sea of passengers are subject to limitation. So a passenger stranded in Dubai, for example, due to the conflict, could in theory claim delay losses within the LMC fund because it's a general limitation, and it's not just purely for personal injury cases, but also for cargo as well. But however, this is likely the quantum may be modest, and it competes with the other priority or hierarchy losses suffered by the passengers, such as the personal injury and deaths obviously would take priority. And then for the Athens Convention, the convention itself does cover death and personal injury and probably luggage loss, which we did not delve in today's presentation, but pure economic loss from stranding, such as probably hotel costs by the passengers who were stranded, missed flights, or probably psychological distress, it kind of, in our opinion, falls into a gray zone. So the Athens Protocol 2002 2 does not expressly cover this, the passenger would then have to rely on their contract of carriage themselves. And this is why we emphasize to passengers to make sure that your ticket terms and whichever consumer protection law applies according to your jurisdictions applies in the forum state that you are. So the practical answer to this is probably there are some gaps that may need to be discussed further in the future.
Right. Thank you very much. I think we are all enlightened by our two speakers. So on behalf of BIAMC, I would like to thank Dr. Osdel also, Ibu Tiana, and also Ibu Fitri, certainly. Thank you very much. I think also to the audience, of course. So today's discussion has shown that in times of conflict like this, maritime law is not only about managing risk after disruption occurs, but also about allocating responsibility before it does. Whenever through careful contract drafting, just like Dr. Osdel mentioned, also insurance mechanism or liability regime. So preparedness remains the key to resilience in global shipping. So with that, I thank you very much. And now it comes to the end. Thank you very much, everyone. Bye-bye.
Very much.